In this chapter, we will explore concepts related to civil law. Once completed with this module, you should be able to identify and describe intentional torts, describe negligence in terms of legal liability, discuss discretionary versus functionary ministerial acts, discuss governmental versus proprietary functions, describe the public duty doctrine, discuss the impact of civil rights on tort claims acts, explain the concept of strict liability, explain the difference between private and public nuisance, explain defamation and the difference between libel and slander, identify and describe forms of invasion of privacy, identify and describe forms of economic torts, and explain the concepts of joint and several liability. The case study to introduce the topics within this chapter places you in the role of an EMS chief for a private ambulance service that is being sued for negligent care, medical malpractice. To begin, the EMS agency itself was not the one that is alleged to have provided improper care, rather it was the EMS providers who are employees of the agency. What burden or liability does your private EMS agency have for the negligent actions of its employees? Does it matter whether the organization is private or governmental in nature? What are some ways your EMS agency can attempt to defend itself against this lawsuit? Are there any legal principles that could potentially be used to undermine the plaintiff's case? These are all issues of civil law, specifically as it relates to the alleged negligent conduct of your employees. If you do not know the answers to these questions, do not fret, you will by the end of this module. To begin our discussion about civil law, we will first define the word tort. A tort, in legal parlance, is simply a civil wrong. This is in contrast to a crime, which is a societal wrong. When a tort is committed, a person or other legal entity, as we discussed in a previous chapter, performs some sort of act or omission that results in damages to another person or entity. The harm caused by the tortfeasor may be physical, financial, emotional, or some combination of those three. The harm may also impinge on other rights afforded to the person, entity, or group as well, and, depending on the nature of the tort, a crime may have also been committed. Some torts are also recognized as crimes. While we previously discussed the applicability of criminal law to emergency service agencies and professionals, civil law really provides greater exposure to legal risk. Unlike criminal law violations, the mental state for many torts, negligence in particular, does not always require intentional or even knowing conduct. Civil law creates liability even for accidents, and as we are all human, accidents are bound to happen. The burden of proof in a civil case is also significantly lower than it is in a criminal case. All this combined means fire departments, EMS agencies, and their employees, managers, and leaders in particular must have some knowledge about civil law concepts so that they can try to minimize exposure to the legal risk associated with tort claims. The first group of torts we need to discuss are intentional torts. An intentional tort occurs when the tortfeasor, the person accused of the wrongful act, commits an intentional and volitional act that harms the plaintiff. A quick example would be one person punching another after some type of provocation. The tortfeasor intended to punch the other person in the face. As soon as that person's fist contacts the other person's face, an intentional tort has been committed. An important facet of intentional torts is that the intent to commit the act itself is enough to establish liability for the civil wrong. Whatever harm results from the intentional conduct need not be intended for the tort to still exist. Take the previous example of punching someone in the face. Say the victim of the punch suffered a detached retina and permanent partial blindness as a result of the punch. The tortfeasor may have never intended to cause such harm to the victim, but that is irrelevant once he or she decided to land the punch in the first place. It is the intentional conduct itself that gives rise to liability for an intentional tort, not an intent to cause the end result, whatever that may be. That end result may play a part in determining the damages suffered by the victim of the civil wrong, but it is not probative in establishing tortfeasor liability for the intentional tort itself. Essentially, if a person commits an intentional tort, damages are presumed, even if one might argue the victim really did not suffer much at all in real or tangible damages. While we have not discussed negligence yet, it is worthy to mention that in some cases, extreme negligence, however that is defined by the jurisdiction, may be considered an intentional tort by the jurisdiction. Along similar lines, because the intent to commit the act itself is enough to establish an intentional tort, the resultant damages can vary considerably due to that bad act. Essentially, the tortfeasor is taking a great risk in committing the intentional tort because he or she has no idea how the victim will ultimately respond to the action. This gives rise to the Eggshell Plaintiff doctrine that states the tortfeasor must take the plaintiff in his or her existing and specific condition. Going back to our previous example, assume that the punch to the face was not that hard and 9 out of 10 people arguably may not have even felt the blow. In this particular case, however, the victim of the punch has a pre-existing injury or condition that resulted in a weak facial bone structure, and the punch that would not have hurt most people actually broke several facial bones in this particular victim, which also played a part in the detached retina we mentioned previously. This eggshell in the Eggshell Plaintiff doctrine refers to the particular fragility of the particular victim. Even if there was no way for the tortfeasor to know that this person had a particular unique condition or frailty that made him or her more susceptible to the injury, that is simply too bad for the tortfeasor, who will find him or herself liable for increased damages that may not have applied if the victim was someone else without that particular condition or frailty. As mentioned briefly before, damages are essentially presumed from any intentional torts. If an intentional tort involves some type of bodily injury, the plaintiff does not need to show any specific damages. Again, the damages are presumed. The plaintiff need only show the intentional tort occurred for the court to award some type of recovery to the plaintiff for the tortfeasor's bad act. This is different from negligent conduct, which we will discuss in just a little bit, where damages are a required element that must be proven by the plaintiff before he or she can recover against the defendant in a negligence case. While proving or sustaining an intentional tort lawsuit may seem easy considering that damages are often presumed, there are several defenses that can be raised to an intentional tort claim. The first defense is that of consent. In some situations, a person may consent to the torturous conduct, thereby eliminating the liability risk for a potential tortfeasor. A great example would be participation in a contact sport such as boxing. If our previous example encompassed 2 boxers in a boxing ring, surely there is intent on both sides to punch the other person in the face. Because this conduct is legal and actually encouraged within this particular sporting event, the potential victim is assumed to have consented to this type of conduct. Such consent can be expressed, whereby someone verbalizes permission to the conduct or maybe signs a release or acknowledgement that the conduct is possible or will occur, or it can be implied given the actions of the potential victim, such as him or her willingly stepping into a boxing ring, a football field, or an ice rink for a hockey game. One thing to keep in mind about consent, however, is that the consent is typically limited to actions normally and reasonably taken within the auspices of the particular activity. Actions that exceed the scope of the consent are not protected. Given our boxing example, it is possible to assume the participants will be punched in various body parts with a gloved hand. In what has become an infamous event in the boxing world, it is probably safe to say that Evander Holyfield never consented to having his ear bitten off in the ring by Mike Tyson, however. For consent to be used as a defense to an intentional tort, that consent must also be freely given. Consent obtained as a result of fraud, duress, or mistake is not valid and cannot serve as an effective affirmative defense to an intentional tort. Self-defense exists when a person reasonably believes he or she is under an imminent and unprivileged attack by another, and that person uses reasonable force to evade, escape, or otherwise stop the attack. In such a case, the level of force used must be commensurate with that needed to stop or escape the attack. If you are the person in our previous example who was punched in the face, if it was reasonable to expect the punches to keep coming, you would arguably be privileged to use a similar level of force to escape or stop the attack. In doing so, if you land a punch or 2 of your own, the original attacker would probably not be successful in maintaining an intentional tort lawsuit against you, as you are simply attempting to defend yourself from the initial attack. If, after being punched in the head, you pulled a knife and stabbed the attacker multiple times, there may be a question as to whether that level of force was necessary or excessive, which could then give rise to liability. Again, the level of force used in self-defense must be consistent with the level of force against which the person is defending him or herself. If the person legitimately feared for his or her life, meaning the assailant was using what could amount to deadly force, the person can then use deadly force in his or her defense. In cases involving the use of deadly force to defend oneself, however, whether or not that fear for one's life is reasonable can often be called into question. Many jurisdictions also impose a duty to flee before deadly force can be used in self-defense unless the original attack occurs in one's residence or, sometimes, place of work or business. Another facet of this defense is that someone who provokes a conflict or attack cannot then claim self-defense when he or she responds to the attack that he or she provoked in the first place. Related to self-defense is the defense of others. Our laws recognize the nobility in coming to the aid of another, and the defense of others doctrine permits a person to come to the aid and defense of another who he or she reasonably believes to be under an imminent and unprivileged attack. Essentially, the law places the Good Samaritan in the shoes of the person being attacked and provides the same privilege to the Good Samaritan that would be available to the actual victim. Notice, however, that both self-defense and defense of others included the term unprivileged attack. This means that there must not be some type of legal basis or permission for the attack for the intentional tort defenses of self-defense or defense of others to apply. As an example, imagine for a moment that you saw someone tackled on the street by another person who then attempted to restrain the initial victim. After you came to the aid of the original apparent victim, you found out later that the person who did the tackling and restraining was a police officer attempting to subdue and arrest a criminal suspect. In such a case, the police officer is privileged to commit what would otherwise be an intentional tort. Therefore, your defense of the person being tackled is not a valid defense, as that person would not have been legally permitted to resist a lawful arrest by a police officer. Defense of property is another intentional tort defense that recognizes the ability of a person to use reasonable, non-deadly force to prevent harm to his or her property. Unlike self-defense or the defense of others, however, defense of property is not as broad of a defense, as the threshold required to legitimize intentional torturous conduct is higher for defense of property than for defending oneself or another against personal injury. Essentially, if the opportunity presents itself, legal remedies must be tried first. To also reiterate, it is never acceptable to use deadly force to protect property. If you see someone stealing your car, for instance, the defense of property defense will not protect you from civil liability if you pull a concealed carry handgun and shoot the car thief. Such an action would almost certainly be considered a crime as well. Given our earlier example of a police officer trying to subdue and arrest a criminal suspect, there are also times when the law recognizes the authority of a person to commit an intentional tort. The first such privilege is the privilege to arrest, which allows police officers to physically and aggressively touch people while effecting such an arrest. Another recognized privilege exists for shopkeepers. Known as shopkeeper's privilege, this type of authority allows a store owner to detain a person accused of stealing or shoplifting while waiting for law enforcement to arrive. Discipline is another recognized privilege that allows parents and, in some cases, other caregivers and authority figures, such as school teachers, to commit intentional torts against children for the purposes of discipline. The fine line here, however, is that the threshold between discipline and abuse can be somewhat difficult to determine, and there has also been a softening of this authority, especially involving non-parental authority figures like school teachers, whereby certain types of discipline that may have been commonplace a generation or two ago are no longer considered to be acceptable. Sometimes, a person finds him or herself between that proverbial rock and a hard place and must make a decision that will result in some harm to someone, and the only thing he or she can do is to try and minimize the resulting damage as best as possible. That is the crux of the doctrine of necessity. Sometimes, in order to avoid substantially greater harm to oneself, one's property, or another, it is necessary to damage the property of another person. In such a case, the defense of private necessity may apply. An example would be someone driving a car in a quiet suburban street when a child dashes out into the street from in front of a parked car. The driver is left with the split-second decision to either hit the child or to swerve and potentially risk hitting a parked car or driving up onto someone's property, which would be a trespass. In such a case, damaging another person's property, such as a parked car or their meticulously manicured lawn, is obviously preferable to striking a child with a car. The private necessity defense to an intentional tort would most certainly apply in such a case. There are also times where it may be necessary to damage the private property of another to avoid a substantially greater harm to the public. A very simple example from the world of wildland firefighting would be the creation of a fire break through private property. Trespassing onto another person's property and destroying trees and other vegetation in the hopes of stopping the spread of a wildfire would be considered a public necessity. True, there may be laws in the jurisdiction that provide firefighters with this authority anyway, but the example does indeed lend itself to illustrating the facets of public necessity. With this background in mind, we can now identify some common intentional torts. The first type or classification are intentional torts that encompass some type of bodily injury. These torts deal specifically with an individual's personal autonomy and the right to be safe from intentional bodily injury. As we go through these torts, they may appear familiar because this wrongful civil conduct was also included within our definitions of criminal conduct. Thus, not only are the intentional acts we are about to define considered to be intentional torts, given their harmful nature, they are also considered to be crimes against society. The first bodily injury intentional tort to mention is assault, where the tortfeasor's volitional intentional act causes a plaintiff to suffer reasonable apprehension of a harm or offensive touching, a battery. Consistent with the criminal law definition of assault, the victim must be aware of the attempted battery. If the victim was never placed in apprehension of the harmful or offensive touching, then assault never occurred. Battery occurs when the tortfeasor's volitional intentional act causes the victim to suffer a harmful or offensive touching of his or her person or an object attached closely thereto. That means if someone runs by a female victim and grabs a purse off her arm, the grabbing of her purse, even though the thief never physically touched the woman herself, is still enough to give rise to the intentional tort of battery, as the purse was an object closely attached to the victim. Remember as well that this is an intentional tort. Tripping on the street and falling into someone is not a battery, as the alleged tortfeasor did not intend to strike, hit, or touch the victim. False imprisonment is similar to the crime of the same name, whereby the tortfeasor intentionally causes a plaintiff to be confined within a bounded area. The dimensions of the area are irrelevant so long as confinement occurs and the victim is aware of the confinement. Thus, the area could be the back of an ambulance, a room, or even an outdoor fenced-in area. The length of time is also irrelevant, as even a momentary restriction will give rise to the occurrence of the intentional tort of false imprisonment. There are also cases where a tortfeasor intentionally attacks or assaults someone emotionally. In many cases, this emotional injury occurs as a result of a bodily injury. When that happens, the recovery for the emotional harm is included within the award for the bodily injury tort. If the victim is alleging emotional damage only, with no accompanying physical harm, the plaintiff must show some type of severe emotional distress to warrant recovery, the key word being severe. This type of claim involves the intentional infliction of severe emotional distress, whereby the tortfeasor commits a volitional, intentional, extreme, and outrageous act that causes the victim to suffer severe emotional distress. In establishing this tort, the victim must show that the tortfeasor, the defendant, engaged in extreme and outrageous conduct with either the specific intent to cause severe emotional distress or with a reckless disregard to its possible occurrence. There are also intentional torts that encompass damage or injury to an individual's real or personal property. Trespass to land is the first such intentional tort where a tortfeasor commits a volitional and intentional physical invasion onto the victim's land. To clarify, it is possible to commit trespass without the intent to enter onto the other person's land, so long as the action that eventually gave rise to the trespass was intentional. A great example is the kid who hits a baseball into the neighbor's window. While the child probably did not intend for the baseball to enter the other person's property, the act of hitting the baseball with the bat was indeed intentional, and the resulting trespass was not outside the realm of possibility. In many scenarios, consent is used as a defense to trespass given local custom, usage, or conduct. For instance, it is acceptable and customary for a person to solicit a homeowner by walking up to the front door and ringing the doorbell. While the solicitor did intentionally enter the land of another, it is recognized as reasonable and customary for such a trespass to be socially acceptable. Thus, by custom and usage, consent is implied. For those of us in emergency services, the assertion of legal authority is also a recognized exception to the intentional tort of trespass. States typically have laws in place that specifically allow firefighters and EMS providers to enter the property of another to mitigate emergencies and perform other administrative duties. Nuisance is another property-related intentional tort in which the actions of another encumber the right to the unfettered use and enjoyment of one's private land. This tort is occasionally the impetus for Hollywood comedies in which one neighbor is too loud or keeps lights on at night that shine directly into someone else's bedroom window. If the intentional and volitional actions of a person causes substantial and unreasonable interference with a single person's use and enjoyment of his or her land, then the victim would have pretty good grounds for a private nuisance lawsuit. If those activities unreasonably interfere with the health, safety, or property rights of the public as a whole, then the claim may more appropriately be one of public nuisance because it impacts more than a single property owner. As far as public nuisance is concerned, a private party cannot bring a public nuisance lawsuit unless the harm suffered by that private party is unique compared to everyone else. Otherwise, public nuisance lawsuits must be filed by the government on behalf of the people suffering the interference to the use and enjoyment of their property. Think about complaints that the nearby airport is making too much noise. As the noise impacts a lot of people, a private party would have difficulty showing that he or she is suffering an interference that is different from others in that area, thus negating the possibility of a private nuisance claim. Along somewhat similar lines, there is also a coming to the nuisance defense that may exist for the alleged tortfeasor. With the airport still in mind, a person cannot move next to the airport and then try to sue for either public or private nuisance because that person knew or should have known about the airport's activities and the resultant noise before purchasing, renting, or leasing the property. That individual is said to have come to the nuisance and cannot later sue under nuisance unless the nature of that nuisance has somehow changed substantially since the person first moved into the area. The last two intentional torts related to property that we will discuss are conversion and trespass to chattels. Chattel, by the way, is simply another way of saying private property. Conversion is the intentional destruction of or serious and substantial interference with a person's private property. This is essentially theft or the destruction of property. Trespass to chattels occurs when a person's intentional and volitional act results in the interference to the use of an individual's private property. This can be somewhat akin to the crime of criminal damage to property. Keying a person's car or slashing the car's tires, for example, would be a trespass to chattel. If the tortfeasor's interference diminishes the use and enjoyment of the plaintiff's private property without actually destroying the property or significantly interfering with the owner's use and enjoyment of that property, the tort is more than likely trespass to chattel as opposed to conversion. As mentioned in the textbook, the difference between the two torts is one of degree. From the perspective of a firefighter or an EMS provider, it should be easy to see how routine actions as part of performing firefighting or EMS duties could very well be considered intentional torts if not for the fact firefighters and EMS providers typically work under legal authority or privilege to perform those duties. Consent, especially in terms of providing emergency medicine, also routinely comes into play as well. It is the application of this legal authority and the concept of consent that allows firefighters and EMS providers to force entry into houses, damage property as a part of fire suppression activities, cut apart cars as a part of an extrication, and physically touch patients and perform invasive procedures without fear of civil liability for those acts. Because consent is such an important concept to avoiding liability for what could otherwise be an intentional tort, especially within the realm of providing emergency medicine, we'll delve deeper into consent at this time. Within the medical realm, there are different types of consent that are recognized, and some states even have laws that define the requirements for obtaining patient consent before performing various medical procedures, especially those that are considered to be invasive. The first type of consent is the clearest cut, if you will. Express consent exists when a potential tort victim gives written or verbal consent to another party to commit an act that would otherwise be considered an intentional tort. A patient who states, "Yes, please start an IV," has given express consent for the paramedic to pierce the patient's skin with a needle and establish an intravenous line. Because the consent is expressed, the consent is limited to only those actions specifically included within the consent that was provided. Thus, given the previous example, just because the patient gave express permission to start an IV does not mean the paramedic can now perform any type of intervention he or she wants. That express consent was limited to the starting of an IV. Additionally, express consent can be withdrawn at any time. People have great personal autonomy rights within the United States, which includes the right to withdraw or withhold consent to medical treatments. Related to that information is the fact that express consent is further limited to intentional torts that are reasonably foreseeable as a result of the prospective intentional act. Thus, just because our patient expressly agreed to an IV does not mean the EMS crew may subsequently forcibly restrain that patient against his or her will in the back of the ambulance, as false imprisonment would not typically be a foreseeable outcome or action as a part of starting a simple IV. Express consent also does not completely alleviate any risk of liability in tort for a potential tortfeasor. While we have not yet discussed negligence, it is very possible for an EMS provider to have patient consent to perform a healthcare intervention, thus alleviating potential liability for an intentional tort, yet the EMS provider performs the skill negligently, thus giving rise to a potential negligence claim by the patient. Express consent obtained under fraud or duress is also not considered valid. An offshoot of express consent is the topic of informed consent. Essentially, informed consent is express consent with full disclosure. Within the realm of practicing medicine, for a person to provide informed consent, the patient must have all the information necessary to make a fully informed decision about the requested consent. This means the healthcare provider must explain the procedure, the potential risks and side effects to the procedure, what could potentially happen if the procedure is not performed, and any other important and pertinent information that would assist the patient in making an informed decision as to whether or not to allow the intervention. Within the realm of EMS in particular, informed consent is typically not required, although it is still considered desirable and lends itself to principles of good customer service. In other medical realms, there can be requirements for express consent to be valid only if it is founded upon principles of informed consent. If it helps, think about the average pharmaceutical commercial on TV. The commercial typically lists all of the potential side effects of taking the medication and tells you what the patient should do if one of the side effects does occur. While this information is provided to avoid issues with products liability, which will be discussed later, the information also helps the physician, who is known as a learned intermediary in this respect, ensure the patient is indeed informed as to the benefits and potential risks of taking the medication. Thankfully, as already mentioned, EMS is typically not bound by requirements to ensure patient consent is informed consent. One of the issues that seems to come up frequently in EMS patient consent discussions is a question of capacity to consent. In order for a patient to provide valid express consent to medical treatment and interventions, the person providing that consent must have the legal capacity to do so. This could be a problematic threshold when working with minors, the elderly, or cognitively disabled individuals, which could also include those who are temporarily impaired by drugs or alcohol. Most states have laws that define when a child becomes an adult with the recognized legal ability to make healthcare decisions for him or herself. While that age is typically 18, there may be exceptions depending on the circumstances or the state. Some states recognize emancipated minors. Other states will differentiate the threshold based upon the medical intervention to be performed, such as an abortion, which may be permissible for a minor without parental consent, depending on the state. In cases where a person lacks the capacity to consent, express consent can be obtained from someone who serves as a legal guardian for the patient. In the case of a minor, if a parent or legal guardian is not available and time is of the essence, the law also recognizes the doctrine of in loco parentis, whereby an adult with authority steps into the place of the parent for making the healthcare decision. This is what happens when a grade school principal provides consent for a child's treatment, or when a child's grandparents, aunt, uncle, or other family member who is not a parent provides consent for treatment. There are also cases where a healthcare power of attorney document may provide someone with the legal capacity to consent to treatment for another person. One important thing to keep in mind is that this discussion relates to legal capacity, not legal competence. The two words, capacity and competence, are often used interchangeably by some EMS educators, but there is indeed a legal difference. Legal capacity is often a somewhat lower threshold than legal competence. Competence may also be something that must be determined by a psychologist, psychiatrist, or a mental health professional. As this differentiation may depend upon the jurisdiction in which one is practicing, it is important to be familiar with the laws in your state as they apply to determining whether someone has the legal capacity to make decisions related to his or her health care. As far as capacity is concerned, the proverbial street runs both ways in that if a patient lacks the capacity to consent to treatment, that same patient also lacks the capacity to refuse treatment. Have you ever been called to respond to a car accident for a 17-year-old patient without injuries and is still transported to the hospital because you are unable to reach a parent or guardian? That is a common scenario that arises when discussing the lack of a minor to either consent to or refuse medical treatment. In many areas, there are laws that require EMS to provide treatment and transport to patients who call unless that patient specifically refuses that treatment or transport. In cases where the patient lacks capacity, the EMS crew then functions under the doctrine of implied consent, which we will discuss momentarily. Before we delve too deeply into implied consent, however, we must still evaluate the ability of someone with legal capacity to refuse care. It has been mentioned on several occasions that United States citizens have tremendous personal autonomy rights. There has also been a great deal of societal change that is beginning to accept the ability of people to accept their proverbial fate and die with dignity if they so prefer. Thus, a patient with legal capacity may refuse medical care or treatment even if it is not in his or her best interest or against the wishes, desires, or advice of a physician or an EMS provider. In those cases, the best anyone can do is attempt to use therapeutic communication techniques to sell the patient on whatever treatment is necessary, prudent, or reasonable given the circumstances. If that patient continues to refuse, however, and the patient has legal capacity to do so, forcing the patient to receive treatment or be transported can give rise to some of those intentional torts that we just discussed. Along those lines, whether or not a physician orders the EMS crew to transport is largely irrelevant as well. Again, the patient with legal capacity has a right to not only consent to treatment, but to also withhold that consent. Typically, the only exceptions are those in which the patient is determined to be an affirmative harm to himself, herself, or others. Some states allow for an emergency detention for a specific period of time to protect the patient or public from himself or herself. Such emergency detentions routinely involve law enforcement or social services, however. Because legal capacity can be a difficult determination to make on an emergency scene, in addition to the probability for harm to the patient who refuses what the EMS crew consider to be reasonable and necessary care, any patient refusal of care or transport should be documented carefully and thoroughly by the EMS crew. Given this information related to express consent, informed consent, capacity to consent, and refusal of care, what happens if an EMS crew is dealing with someone who lacks the capacity to consent? Maybe it is a minor patient, someone with dementia, a patient with a significant head injury, an obviously inebriated patient, or an unconscious patient. What does the EMS crew do in that situation? Luckily, the legal principle of implied consent has evolved over a considerable period of time to address such occurrences. Essentially, if there are emergent circumstances and it is not possible for express consent to be obtained, the doctrine of implied consent applies, whereby the law assumes the person or the person's guardian would want the healthcare provider to take whatever steps are reasonable and prudent to help the person. To go a step further, EMS providers may routinely function under implied consent when a patient does not take affirmative actions to withhold consent. When someone calls 911 for EMS, it is assumed that the person wants help. Even if the person was not the one who called, there is a routine and reasonable understanding of what EMS providers do and what certain actions mean or imply. If the paramedic arrives on scene, makes contact with the patient, and starts to apply a blood pressure cuff, the patient's lack of objection to the taking of a blood pressure is essentially implied consent, even in the absence of the paramedic asking the patient for permission to apply the blood pressure cuff and obtain the patient's blood pressure. Implied consent is obviously very important when dealing with individuals who lack the capacity to consent. In one of the previous examples, I mentioned transporting a 17-year-old who was in a car accident even though the patient had no apparent injuries and did not want to be transported. In that case, because the patient lacked legal capacity, principles of implied consent applied, and the EMS crew needed to function as though the patient's parent would want him or her to be treated for potential injuries. In cases where there is a true emergency and express consent cannot be obtained, implied consent is a necessity. When functioning under implied consent, it is important to recognize that such consent is limited to those actions that are reasonably necessary to mitigate that condition or circumstance. Say an EMS crew is called for a pulseless non-breather and arrives to find bystanders performing CPR. Implied consent would apply for the crew to follow their protocols for that type of emergency, which would include CPR, defibrillation, IV access, and other pertinent skills and treatments. While the example is obviously absurd, that same implied consent would not allow the EMS crew to conduct a field amputation of a limb because they felt like it. Additionally, if the patient somehow regains legal capacity during the course of treatment, the patient has the ability to affirmatively withhold consent for additional or continued treatment. While we have focused on EMS in particular within the past few slides, there are other services provided by fire departments and EMS agencies that rely on consent. With that being said, there are also times where the law itself may impose a legal obligation to act on the fire department or EMS agency, which essentially removes the need for any type of consent. One such example would be the extinguishment of a fire. If a fire department is called to extinguish a house fire, for instance, the lack of homeowner consent is irrelevant, as many states impose a legal obligation on the fire department to extinguish such fires. At this point, we are going to shift from intentional torts to negligence. Unlike an intentional tort, negligence occurs accidentally, so to speak. No one intends to cause harm through negligence for the most part, but that lack of intent does not sever civil liability for unreasonable action. Simply stated, negligence occurs when one person owes a duty to another, the person fails to act reasonably, and that action or failure to act causes damages to the victim. In such a case, the harmed party can seek redress for his or her injuries from the negligent party deemed responsible for those injuries. Again, there is no requirement that the negligent actor intend to cause harm. While some textbooks list anywhere from 3 to 7 elements that give rise to negligence, this particular textbook denotes 4 elements to the civil tort of negligence. A duty was owed, there was a breach in that duty, causation, meaning the breach caused the harmed party's injuries, and damages. The first element of negligence, duty owed, is where we will begin our discussion. Before a civil defendant can be found liable to another in negligence, there must have existed a duty between the parties. The defendant must have owed a duty to the plaintiff. Generally speaking, people have a duty to avoid foreseeable harm to foreseeable victims. Stated another way, people must act reasonably toward another. This is the basic premise of the duty owed in a negligence case. As far as this duty to act reasonably is concerned, that duty is owed to the public as a whole and not to any one individual. Essentially, with the exception of some very limited circumstances, the law does not impose a duty on any one person to take affirmative actions for the benefit of another. As an example, if I am driving on the freeway and see a horrific accident, there is no duty that requires me to stop and render aid as a private citizen. While some may argue that is the moral or ethical thing to do, the law generally does not require it. This concept is important for governmental agencies and employees because it translates into something known as the public duty doctrine, which holds that police and fire departments owe a general duty of service to the public as a whole. There is no duty owed to any specific individual. While it may seem odd, it helps to think of this doctrine from the perspective of a police department, as many police departments prioritize their calls and, depending on the jurisdiction, may even refuse to respond to specific types of calls. The police departments in some communities, for example, refuse to respond to automatic burglar alarms or to noise complaints or for reports of theft from a vehicle. If someone does call with a complaint that is considered minor, the police department may choose to move that call down in the queue and respond when they have the capacity to respond. That is the impact of the public duty doctrine. Unless the governmental agency established a special duty upon which the caller relied to his or her detriment, a duty to act probably does not exist given the public duty doctrine. With that being said, there are cases where a special duty does indeed exist between two parties, giving a rise to a duty to act. One such circumstance is when the defendant causes the peril to the plaintiff. Another is if the defendant promises to render aid or actually started rendering aid to the plaintiff. A third scenario is when a special relationship exists between the defendant and the plaintiff, such as the special relationship between a parent and a child, a school teacher and a child, or a lifeguard and someone swimming in his or her pool. Given the existence of a special duty for one of these reasons, the first element of negligence, a duty to act, presumably applies. For EMS providers, a special relationship is typically created when a promise to render aid is made. There have been cases where someone called 911, the dispatcher told him or her that help was on the way, and the person waited for an ambulance that never showed up or showed up very late to his or her detriment. In those cases, a special duty was created that negated the public duty doctrine. The negligence lawsuit did not fail due to a lack of a duty to act. Other special relationships commonly involve caregiver or custodial relationships like the parent-child or teacher-child relationship just mentioned. There are also special relationships that could give rise to a duty to act given specific circumstances. We already mentioned the special relationship that exists between a lifeguard and a swimmer in his or her pool. A special relationship could also be created if a police officer, for instance, promises to provide a homeowner or property owner with special patrols or building checks. When talking about the duty owed to another person, we must also talk about the duty owed to someone who owns real property, land or buildings, to others who may enter that property. Essentially, owners of real property owe a duty to individuals who enter that property. The level of duty owed has historically fluctuated based upon the individual's status on the property. Someone who trespasses onto another's property is there without permission, and the duty owed to that person by the property owner is to simply avoid willful or wanton harm to the trespasser. If someone is on your property with permission and that person is in a position to confer an economic benefit to the property, the law considered that person to be an invitee, and the property owner owed him or her a duty of reasonable care, which is similar to the duty owed generally to other people. Licensees are also on another's property with permission, but do not confer an economic benefit to the property owner. Licensees must commonly be warned by the property owner about known or concealed dangerous conditions on the property. In some jurisdictions, a licensee is actually treated like a trespasser, and the property owner owes that person no duty beyond avoiding willful or wanton harm. Given the definition of a licensee as someone on the property with permission who does not convey economic benefit, social guests, family, friends, and emergency workers are routinely considered to be licensees. Again, they are there with permission, but do not convey an economic benefit that would increase the level of care they are owed by a property owner. Being a landlord does give rise to some unique wrinkles in the duty owed to those on the landlord's property. To begin, once a tenant takes possession of a property, all landlord obligations pass to the tenant. There are exceptions, however, where a landlord is still ultimately responsible for his or her property. These duties include the requirement to fix latent defects in the property, an overall responsibility for common areas on the property, which includes a duty of reasonable care, and if the property is open to the public, the landlord retains an affirmative duty to find and repair dangerous conditions that exist on the property. So why are we discussing the duty owed to others by property owners and landlords? Aside from the fact that fire departments and EMS agencies own property and are responsible for maintaining that property to different levels given the type of people visiting their property, firefighters and EMS providers often enter the property of others as a part of their routine duties. Given the nature of emergency work, however, something called the Firefighter's Rule has evolved over time to reduce the potential liability for property owners, and others for that matter, when dealing with professional rescuers who knowingly and willingly accept a certain amount of risk while performing their duties. Essentially, the Professional Rescuer Doctrine, or Firefighter's Rule, prevents emergency workers from suing members of the public for injuries suffered as a result of negligent actions that created the circumstances that prompted the emergency response and mitigation activities. As just mentioned, emergency workers assume a great deal of inherent risk in the performance of their duties. There is also tremendous social utility in having fire departments, EMS agencies, police departments, and the people who respond as a part of those agencies. When someone is in trouble or needs help, we as a society want that person to call for help. More importantly, we want that person to be able to call for help without fear of legal liability for injuries to professional rescuers who respond to that call for service. The last thing we want as a society is for someone to not call 911 for help when they need it because they are worried about being sued by a police officer, firefighter, or EMS provider if that individual is hurt as a result of the caller's own negligent actions. One such case heard by the Wisconsin Supreme Court involved a firefighter who suffered a back injury at the scene of a car accident and subsequently sued the person responsible for the car accident for his injuries. The firefighter's rule precluded his claim, and the lawsuit was eventually dismissed. With this in mind, many courts and state legislatures have begun to soften the firefighter's rule in cases where the risks faced by the responders were completely unknown or unforeseeable by the emergency workers, or where emergency workers are the target of an intentional tort or a criminal act. Given that the first element of a negligence claim is to prove that the defendant owed the plaintiff a duty, the next element, once a duty is established, is that the defendant breached that duty to the plaintiff. When evaluating whether the duty owed to the plaintiff was breached, the law uses a reasonable and prudent person standard. The standard is an objective one, not a subjective one. It is ultimately up to a jury, if a negligence case goes that far, to determine whether the defendant's conduct was objectively reasonable and prudent given the circumstances of the case. Because the standard is objective, it does not fluctuate based upon the defendant. Thus, the subjectivity and perspective of the defendant is not determinative in whether or not a breach of duty occurred. As far as firefighters and EMS providers are concerned, we have specialized knowledge, training, and experience that the general public does not have. As a result, in cases involving professionals, such as firefighters and EMS providers, the objective standard is elevated from that of a reasonable and prudent person to that of a reasonable and prudent professional. This means the jury will try to determine what a reasonable and prudent professional with similar education, training, and experience would have done in the same or similar circumstances when trying to determine if a breach of duty occurred. In such a negligence case involving this reasonable and prudent professional standard, the established standard of care in the industry becomes very important. This standard of care is the measure of duty owed by the professional to the plaintiff, and it can be established by numerous potential resources, such as a fire department standard operating procedures or guidelines, EMS protocols, educational textbooks, published journals, and expert witness testimony. In evaluating whether or not a breach of duty occurred, there are some circumstances in which it can be difficult to show that a breach occurred, yet it is easily and commonly recognized that the harm suffered would have never occurred absent negligence. An example would be a patient who is injured because the cot on which he was on tipped over. How does that injury happen without negligent conduct? Unless there was an intentional act that caused the cot to tip, such an occurrence is almost certainly the result of some type of provider negligence. From a legal standpoint, however, it may be difficult to prove that the breach of duty occurred because there may be no clear standard as to how a patient is supposed to be moved on a cot, or the patient was unconscious on the cot at the time and there were not witnesses, or who knows what. In such cases, there is a legal principle called res ipsa loquitur that may be used to establish the breach of duty in a negligence case. Again, for res ipsa loquitur to apply, it must be reasonable to infer that a breach of duty occurred, even if a specific breaching act cannot be shown. Just to be clear, all this does is establish the breach of duty. The other three elements of negligence must still be proven to support a claim of negligence. Thus, res ipsa loquitur is not necessarily a silver bullet that proves a negligence case. All it does is establish the breach of duty, assuming one existed. Causation and damages must still be proven. There are also some cases where, under appropriate circumstances, a civil court may adopt a criminal statute or regulation as the standard of care to be used in a negligence case when evaluating a breach in the duty of care. Such a violation of a law that establishes a breach of duty in a negligence case is recognized as something called negligence per se. So long as the law was established to prevent the type of harm that was suffered by the plaintiff, the law will often serve as a threshold for determining what is or is not reasonable conduct. An easy example is breaking a traffic law that results in an injury to someone else, such as running a red light. The law requiring drivers to stop at a red light is the applicable standard of care, and breaking that law establishes the breach. Once we know that a duty was owed by the defendant to the plaintiff in a civil negligence lawsuit, and that the defendant breached that duty, causation is the next element that must be proven to sustain the negligence lawsuit. Essentially, the plaintiff must show that the defendant's conduct was responsible for the plaintiff's injuries or damages. In evaluating causation, there are two different types that must be confirmed by the court. The first is called actual cause. This is a but-for test whereby the court determines whether or not the defendant's actions were a substantial factor in causing the plaintiff's injuries. But for the defendant's actions, the plaintiff never would have been injured. The second component of causation is proximate cause, which is sometimes called legal cause. This is an evaluation to ensure the breaching act is close enough in time and circumstance to still be a factor in the plaintiff's injuries. Essentially, there is a point in time or sequencing whereby a person's negligent actions can no longer be considered the direct or proximate cause of an individual's damages. Say, for example, you are negligently driving an ambulance red lights and siren to a call, meaning you are probably not driving with due regard, as often required by applicable laws. Someone pulls over as required by law but does so negligently and causes an accident. The person injured in that accident then decides to not only sue the driver of that car, but also sues the ambulance service, alleging that the accident would have never occurred if the ambulance had not been driving red lights and siren. While there is a case to be made that the ambulance response is the but-for cause of the accident, as the accident never would have occurred but for the ambulance's emergency response, it would seem inappropriate or wrong to hold the ambulance driver responsible for the accident given a proximate cause evaluation. True, the claim may lack merit because the ambulance driver did not breach a direct duty to the plaintiff, but the claim would also fail given this lack of proximate cause. Lastly, once duty, breach, and causation are established, the plaintiff must be able to show that he or she suffered damages as a result of the negligent conduct. These damages could include physical injury, damage to property, and even emotional distress. While we are talking about negligence specifically and recognize that proving damages is a required element in a negligence claim, the financial component of calculating damages occurs for all type of tort actions, not just those based in negligence. In discussing damages, it is important to understand that our tort system functions under what is known as the legal fiction that money makes everything better. If someone is physically injured by a defendant, the injury has already occurred and, depending on the nature of that injury, it may be impossible to restore the plaintiff back to his or her original pre-injury condition. Because we cannot magically restore health, we use money as a way to compensate a tort plaintiff for the damages or injuries he or she suffered at the hands of another. When calculating damages, the first kind to be determined are compensatory damages. These are damages that directly reflect the injury suffered. If the plaintiff suffers a physical injury, this is the value or worth of that injury. If there is property damage, it is the lost value of the property or the cost of repairs. Some expenses, such as direct expenses, are easy to calculate. If a person injured in a car accident has $100,000 in medical bills and $15,000 in automotive repair as a result of the accident, the compensatory damages from those two direct expenses are easy to calculate as the sum of the two. Personal injury damages can be more difficult to quantify, however, as the impact of a similar injury can have different repercussions based upon the plaintiff. If Tom Brady and I are both in a car accident and both suffer the loss of our right arms, the loss of that right arm has a greater financial impact on Tom Brady than it does to me. True, we both suffered the same injury, but I can probably still work in my current position, whereas Tom Brady's loss precludes him from being an NFL quarterback, which ends what is arguably a very lucrative career. If the same injury occurs to a 90-year-old versus a 10-year-old, the damages are different and, in the case of the 10-year-old, even more difficult to calculate because we have no idea how that injury will impact the child's future earning potential as an adult. In some cases where the tortfeasor acts with bad intent, recklessness, or a complete disregard for others, the court may choose to punish the defendant for that bad conduct. In such a case, punitive damages may be awarded. While these punitive damages are designed to punish the bad behavior of the tortfeasor, they also serve a secondary function by sending a strong message to others that the defendant's behavior was unacceptable and any similar occurrences of the same behavior by another will be punished as well. The words often used to describe such bad behavior is willful and wanton. As a matter of fact, that is a language that was used by the court that decided what is now the infamous 1994 product liability court case of Liebeck versus McDonald's. For those not familiar with the case, and even those who think they are, McDonald's served their coffee at a temperature that McDonald's actually stated in its own testimony was unfit for human consumption and would cause serious burns in seconds. Unfortunately, that is exactly what happened to the plaintiff, Stella Liebeck, when the coffee spilled in her lap. While I am paraphrasing the testimony, McDonald's essentially stated they knew their coffee could cause injury, but they refused to do anything about it because They're McDonald's. Because McDonald's attitude was so flippant in the case, and because they marketed and served a food product they knew would cause burns and was unfit for human consumption at the temperature at which it was served, the court awarded punitive damages in the case. If you have not reviewed the facts of this case, I would suggest that you do so because there is a lot of misinformation out there about the case, and it has grown into somewhat of an urban legend. The short story is that an old woman spilled coffee on herself and sued McDonald's for millions of dollars. It is often used as the poster child case for tort reform, but those selling that narrative fail to tell the whole story. We do not have the time to explore this very interesting case here as a part of this lecture, but I would encourage anyone interested to research what actually happened in the case. Another type of damage award that exists is something known as nominal damages. Nominal damages are awarded when a plaintiff's rights have been violated, but the plaintiff arguably did not suffer any substantial injury or loss. Trespass is a good example of a tort that probably occurs all the time. When I was a kid, I used to cut through the neighbor's yard on my way home from school. Technically, a trespass occurred. If the neighbor sued me for trespass, which is an intentional tort, I would have been found responsible for committing the trespass, but one would have to wonder exactly what type of damages the neighbor suffered from me walking across his or her lawn. Arguably, the neighbor suffered no actual damages beyond the fact the neighbor had the right to not have anyone in his or her yard without permission. In such a case, nominal damages, usually $1 or $2 in many jurisdictions, would probably be awarded. Obviously, given the low dollar amount associated with a nominal damages award, it is usually not worth pursuing a lawsuit in such a case, which is why we probably do not see many lawsuits for an innocuous trespass as I just described. The last type of damages routinely available to a plaintiff in a tort case are statutory damages. While not common for most tort claims, there are some jurisdictions with laws that mandate a specific award of damages for a particular civil wrong. As these damages are prescribed by law, the court commonly has very little latitude in awarding them or varying the amount associated with the award. For those providing EMS, it is probably worthwhile to note that many states now consider medical-related negligence to fall under medical malpractice laws within the state. The elements are essentially the same as negligence, but because the alleged negligence relates to providing medical care, such negligence is referred to as medical malpractice. Those are essentially the four elements of proving a negligence case: duty, breach, causation, and damages. Some legal scholars consider negligence to have a fifth element, the lack of a defense. Rather than viewing the lack of defenses as an additional element to negligence, we'll discuss defenses to negligence as something that can be raised after duty, breach, causation, and damages are established in a negligence case to mitigate, reduce, or alleviate the defendant's responsibility in the case. To begin, the first affirmative defense that can be raised in a negligence case is to simply show the absence of one of the four elements to negligence. If there was no duty, there was no breach of duty, there was no causation, or there were no damages, then the elements of negligence have not been established, meaning there was no negligence and the plaintiff cannot recover against the defendant under the tort of negligence. If all four elements are established, however, the defendant may possibly raise several legal defenses that could preclude, bar, limit, or otherwise mitigate the plaintiff's recovery. The first defense, especially for governmental agencies, is legal immunity. Such immunity means that a party, entity, or individual is immune from liability for certain acts, even if those acts result in harm to another person or entity. There are two types of legal immunity that may apply for governmental agencies: sovereign and statutory immunity. We will begin first with sovereign immunity, which has its roots in English common law. Essentially, back in the day, it was not possible to sue the king. When the United States was originally formed, this mentality carried over from English common law, and it was not possible to sue the government. This meant that the government was not liable to any individual for the consequences of its bad actions, and there was no recourse for a person who was wronged or harmed by the actions of the government. To a certain extent, this also made practical sense, as a lawsuit against the government is really a lawsuit against the public and the taxpayers themselves. After all, if the government loses a lawsuit, who pays? The taxpayers. Because the person suing the government is more than likely a taxpayer him or herself, that person is therefore suing him or herself to a certain extent. Over time, however, public sentiment changed and tort claims acts were passed by the federal government as well as by the states that allowed private parties to sue the government for injuries suffered due to government action. Sovereign immunities slowly became the exception rather than the rule as a result of these acts, and all states, along with the federal government, have tort claims acts in place that allow lawsuits against the government given specific circumstances. The Federal Tort Claims Act retained governmental immunity for intentional torts, and many states have similar provisions. Many tort claims acts, including the Federal Tort Claims Act, differentiate between discretionary versus functionary or ministerial acts when determining whether or not immunity applies or a lawsuit can be maintained. In tort claims acts that recognize the distinction, immunity routinely remains for those acts of government and its employees that are considered to be discretionary. Essentially, if the government actor has discretion in making a decision and that decision resulted in harm to another person, that decision and subsequent act cannot be the basis for a lawsuit against the government. Over time, courts have struggled with the difference between discretionary and ministerial acts, and different courts in different jurisdictions have sometimes reached different conclusions. For example, is driving a police car a discretionary act or a ministerial one? Some courts feel there is discretion in how a person drives an emergency vehicle, thus making the action discretionary. Other courts feel that drivers, even those driving emergency vehicles, must still follow the laws and their local protocols while operating with due regard for the public. Such responsibilities are the basis for considering driving an emergency vehicle to be a ministerial act. The distinction is important as a failure to perform a functional ministerial act can typically serve as the basis for a tort claim against a governmental entity and its employees. Some tort claims acts also differentiate between the type of function being performed by the governmental entity. If the government is involved in what is known as a proprietary function, something that is well within the purview of private entities, tort immunity is commonly not provided for the governmental entity. Such proprietary functions are commonly conducted to make profit or to benefit the government as opposed to the public at large. One of the most common examples is a governmental-owned and operated parking structure. Private companies often own and operate such parking structures for a profit, and the government could even be considered a competitor against those private businesses. Such activities typically generate revenue, which can also be a factor in determining their nature as proprietary as opposed to governmental. Such proprietary functions are not afforded tort immunity. Governmental functions, in contrast, are those functions that are routinely performed only by the government, typically because they are cost prohibitive for private industry. Maintaining a police department or a Department of Public Works is more than likely a governmental function afforded immunity protection. Fire departments and EMS agencies in particular could be a gray area, as there are areas of the country where there are private fire departments and, even more prevalent, private EMS agencies that seek to earn a profit. The primary reason why governmental functions are commonly immune from tort liability is because the government cannot mitigate its legal risk like a private provider by simply avoiding that particular function. For example, while there are private EMS agencies that exist, there are a lot of areas not served by private entities because it is not financially beneficial to a private agency to do so. In such a case, the government is essentially forced into providing those services. By being forced into providing such services, the government cannot avoid the liability associated with those services by simply deciding to not provide those services, or to reduce the level of service to one where maybe it does not allow the use of lights and siren. We as a society want EMS in our communities, and if there are no private providers of those services available, we want the government to pick up the slack. In being forced to undertake that function or role, the government is then allowed immunity protection under many tort claims acts for performing that essential governmental function. As mentioned previously, we also recognize that financial support for governmental functions come from the taxpayers. At some level, society expects individuals to absorb a certain amount of inconvenience, if you will, for the benefit of society as a whole. When someone sues the government, they are really suing the taxpayers. Depending on the nature of the activity being performed by the government, the Tort Claims Act may seek to prevent lawsuits against the government to also protect the taxpayers and shift the burden for potential losses to individuals who may be in a better position to mitigate those potential losses through insurance or other preventative activities. Another potential tort defense for governmental entities is one that was already discussed briefly, the public duty doctrine. Again, the public duty doctrine states that the government owes a duty to the public as a whole. It does not owe a duty to any individual person or entity. Thus, if someone tries to sue the government for inadequate services, the government may be able to use the public duty doctrine to defend against that lawsuit. Keep in mind that there are cases where a special duty exists or is created by the government's actions, in which case the public duty doctrine will not shield the governmental entity from legal liability. Some states have also started to erode the strength of the public duty doctrine, predominantly through court decisions over the course of time. Beyond tort claims acts, some state laws may provide specific statutory immunity for specific acts or entities. Thus far, the defenses to tort liability that we have discussed applied only to governmental actors and entities. Statutory immunity, on the other hand, may apply to both governmental actors and private entities or individuals alike, depending on the law. An example from the world of fire and EMS could be a mandatory reporting law. If a firefighter or EMS provider suspects child neglect or abuse, the law commonly requires the firefighter or EMS provider to report that suspicion to law enforcement. The person being accused of the neglect or abuse may not like it and may try to bring a defamation lawsuit against the firefighter or EMS provider. Such laws usually presume that mandatory reporter, the firefighter or EMS provider in this case, acted with good faith and provides both criminal and civil immunity for making such a report. Such a protection applies regardless of whether the firefighter or EMS provider works for a governmental entity or a private service. Many states also have Good Samaritan laws that are designed to encourage people to come to the aid of others in need. Such statutes commonly provide civil immunity for good faith actions taken in an effort to provide aid to another person at the scene of an emergency. To clarify, these laws commonly require the Good Samaritan to be a volunteer and do not apply to a paid rescuer. Thus, if a firefighter or EMS provider is sued for actions performed while on duty with his or her agency, the Good Samaritan statute will typically not apply. The federal government also passed the Volunteer Protection Act in 1997 to encourage more people to volunteer their time and efforts to charitable causes. This law provides immunity protection to individuals who volunteer their time and efforts to governmental agencies and charitable organizations. The person must be a volunteer in the truest sense of the word, however. If the person receives compensation or anything of value that exceeds $500 per year, he or she is no longer protected by this law. Additionally, the law only covers acts of simple or ordinary negligence. Willful or wanton negligence, intentional torts, and criminal acts are not covered. As far as these various types of immunity are concerned, they are commonly not completely unbridled, as immunity protection typically does not extend to acts of gross, willful, or wanton negligence. In addition, some states recognize the applicability of what is known as the insurance waiver exception. This limitation applies to civil liability caps, which we will discuss a little bit later in this presentation. Simply stated, a civil liability cap limits the amount of money a plaintiff can recover against an entity in a tort action. If an insurance waiver exception applies, however, the defendant essentially waives the civil liability cap up to the value of the insurance available. Say, for instance, that your state places a blanket civil liability cap on claims against governmental entities at $50,000. If a governmental entity has auto coverage insurance that provides up to $1 million per accident and the insurance waiver exception applies, the agency waives the $50,000 cap up to the value of the $1 million policy. Some states do have laws that specifically state that the insurance waiver exception does not apply in certain cases. As always, it is important for you to be familiar with the laws in your particular state. Where mutual aid and interagency compacts are concerned, there can also be immunity complications when a covered entity utilizes the services of an entity that is not covered under an immunity provision. Take the previous example where a state provides a $50,000 civil liability cap for governmental entities. If a municipality provides EMS services and has automatic mutual aid in place with a private, non-governmental ambulance service, what happens if there is a lawsuit against the private ambulance service from a call provided as a part of the mutual aid agreement? Does the private service somehow fall under the civil liability cap umbrella for governmental entities, even though it is a private entity? Can the municipality be successfully sued for an amount in excess of the $50,000 for using a private service that does not fall under the auspices of that cap? Unfortunately, depending on the jurisdiction, such answers may not be very clear. Another limitation on immunity provisions is that the government is still liable for some actions that are codified elsewhere as providing for private recovery against the government. In continuing our previous example, our state may limit recovery against governmental entities at $50,000 unless the nature of the lawsuit involves a motor vehicle collision, at which point the cap is increased to $500,000. Sometimes the applicability of immunity or liability caps can depend on the nature of the lawsuit and the specific laws that apply. If a governmental actor deprives someone of his or her constitutional rights, whether it is done intentionally or negligently, no immunity exists, and the injured party may sue the government for redress based upon that deprivation of his or her constitutional rights. Another defense to a tort lawsuit includes the statute of limitations that applies to the specific type of claim or lawsuit. Every state has a statute of limitations for filing lawsuits that prevents excessive lag in filing tort claims. People should not have to look over their shoulders for the rest of their lives for a civil wrong. At some point, if a lawsuit is not filed for a civil wrong, the potential defendant should be able to breathe easy and put it behind him or her. It can also be unfair to expect a person to defend him or herself against a lawsuit that was not filed within a reasonable period of time, as the memory fades and evidence is corrupted, damaged, or lost. Statute of limitations define the amount of time a plaintiff has to bring a lawsuit against another party for a civil wrong. If the plaintiff does not file a lawsuit within the time frame defined within the appropriate statute of limitations, the plaintiff loses the right to do so. This is another area where familiarity with the laws in your state is important, as the statute of limitations for various types of lawsuits can vary considerably from state to state. Within a single state, the time frames can also fluctuate based upon the type of claim. A lawsuit for medical malpractice may have a different statute of limitations than that for an intentional tort or a simple negligence claim. There is also a legal doctrine known as laches. Laches recognizes that there may be circumstances in which an unreasonable delay in pursuing a claim against a potential defendant may have a detrimental effect on the ability of that defendant to build a case in his, her, or its own defense. There is no specific date or time frame that applies in the use of laches as a defense. Given that the statute of limitations provides a considerable hard deck, if you will, for the time frame in which a lawsuit must be filed, laches is applied sometime before the drop-dead date provided in the statute of limitations. On the back end of the lawsuit, there is also a legal principle known as res judicata, which is Latin for a matter judged. This is the civil court equivalent of the criminal court's prohibition against double jeopardy. Once a civil matter is tried and final judgment is rendered, the case cannot be retried. Depending on the nature of the case, there may be an appeal filed, mind you. At some point, however, all opportunities for an appeal are exhausted and the decision must stand. The matter is considered closed and cannot be revisited in a subsequent lawsuit based upon the same subject matter. Within the realm of negligence, there are also the defenses of contributory negligence and comparative fault. For the layperson, the two may sound similar, and it may not be uncommon for both concepts to be lumped together as contributory negligence, but they are indeed two different things, and the distinction between them is very important. Contributory negligence was originally developed to recognize that there are times when the plaintiff shares some responsibility for his or her injuries or damages. Sure, the defendant may have failed to stop at the intersection stop sign, but it turns out the plaintiff also neglected to stop at the four-way stop. In such a case, the plaintiff obviously shares some responsibility for his or her own injuries. If a jurisdiction uses contributory negligence, this means the plaintiff cannot recover from the defendant as his or her own negligent actions contributed to the injuries suffered. With that being said, there is no formula or threshold to determine how much contributory negligence is enough to bar recovery against the defendant, as any negligence on the part of the plaintiff would essentially end the lawsuit. As an example, if the plaintiff is determined to be 1% at fault for the accident, the plaintiff loses the lawsuit, even though 1% of responsibility is definitely a marginal percentage of responsibility. One interesting wrinkle in jurisdictions that have contributory negligence is the last clear chance doctrine. If the defendant could have avoided the harm by reasonable care in the final moments before the negligent act, the plaintiff may be able to sustain the lawsuit despite his or her own negligence because the defendant had the last clear chance to avoid the act or circumstances that caused the plaintiff's damages. On the flip side, the defendant may also be able to use the last clear chance doctrine as a defense if the plaintiff had the opportunity in the final moments before the negligent act to prevent damages from occurring. Because contributory negligence is obviously very harsh to the plaintiff who may have contributed to his or her own injuries, most jurisdictions use something called comparative fault when evaluating negligence cases. Under the doctrine of comparative fault, a plaintiff's recovery against the defendant is prorated by the amount of his or her own negligence. Given our previous example, if a plaintiff is 1% at fault for his or her own injuries, which totaled $100,000 for the sake of making the math easier, the plaintiff may recover $99,000 against the defendant. The recovery is reduced by the 1% for which the plaintiff is responsible. Within the doctrine of comparative fault are two different models. The first is called pure comparative fault, in which the plaintiff's recovery is based upon the total amount of damages and the various percentages of responsibility for each party. Let's take our previous example and switch the percentages of responsibility around. Rather than only being 1% at fault for his or her own injuries, assume for a moment that the court determines the plaintiff is 99% at fault for his or her own injuries. Given $100,000 in damages, the plaintiff may still recover 1% or $1,000 from the defendant, even though the plaintiff was more responsible for his or her own injuries than the defendant. If you think it sounds strange to be able to sue someone for injuries that were predominantly the plaintiff's own fault, many would agree with you, which is why there is also something known as modified comparative fault. Under modified comparative fault, if the plaintiff's level of negligence is greater than the defendant's, essentially the plaintiff is 51% or more responsible for his or her own injuries, the plaintiff is barred from recovery against the defendant. In continuing the previous example, if the plaintiff was 99% at fault for his or her own injuries, the defendant will win the lawsuit and have to pay nothing to the plaintiff under the doctrine of modified comparative fault. Another potential defense to tort liability is the assumption of the risk defense. This is an argument made by the defendant that the plaintiff willingly engaged in the activity from which the injuries resulted with full knowledge of the personal risks involved in the activity. This defense often applies to participation in sports, recreational activities, and thrill-seeking adventures. The effectiveness of this defense depends on the nature of the activity and the jurisdiction in which the activity is performed. Based upon those factors, the defense may help in reducing or eliminating liability for potential defendants and may even bar recovery completely. One limitation associated with this defense is that it usually only applies to common or ordinary negligence. Willful and wanton negligence, in addition to reckless conduct or intentional acts, are typically not afforded the same level of protection as ordinary negligence by this defense. An individual's assumption of the risk can be expressed or implied based upon conduct. Express assumption of the risk is a contractual concept in which the plaintiff agrees, either orally or in writing, to relieve the defendant of liability for negligence if something bad happens. Such agreements, commonly referred to as waivers, are used frequently in organized recreational or sporting activities, especially those with a considerable amount of inherent risk. Again, even though an individual may expressly assume the risk for an activity, courts are hesitant to apply the defense in cases involving reckless conduct, intentional acts, or willful and wanton negligence. In the absence of a written or oral agreement indicating the plaintiff assumed the risk for the activity, that assumption of risk may be implied or assumed under certain circumstances given the plaintiff's conduct. If one can imply from the plaintiff's actions that he or she assumed the risk of whatever activity he or she was participating in, the defendant arguably owed no special duty to that individual. If there is no duty owed, then the first element required to prove negligent conduct does not exist. This is essentially how the firefighter's rule operates. The professional rescuer knowingly assumes the risk associated with his or her duties, meaning the person he or she is trying to help owes that firefighter or EMS provider no duty. There are also times where a plaintiff may have aggravated his or her own injuries by failing to take reasonable steps to reduce additional harm. In such a case, the plaintiff's failure to take reasonable steps to reduce additional harm may indeed reduce the plaintiff's recovery against the defendant. A somewhat related defense to avoidable consequence is the mitigation of damages. Essentially, once an injury occurs, the plaintiff has an obligation to take reasonable steps to minimize the harm he or she suffered at the hands of the negligent tortfeasor. The plaintiff cannot simply allow the effects of the civil wrong to accumulate or compile unabated in the hopes of obtaining a greater damages award against the defendant. It is also not uncommon for parties to a contract to shift the legal burden for a particular risk within the contract. Hold harmless agreements, indemnification clauses, and subrogation language are all designed to shield one party or another in a contract from the risks of legal liability for actions related to the terms of the contract. As already mentioned previously, many jurisdictions also have laws that cap civil damage recoveries. Such laws limit the amount of money the plaintiff can recover, even if the defendant is 100% responsible for the plaintiff's injuries. In some states, there are also civil liability caps that apply specifically to governmental agencies or activities. A good example of broadly applicable civil liability caps are those related to medical malpractice claims and caps against recoveries that exceed a certain threshold, which can vary by state. Where governmental agencies are involved, it is also not unusual for a state to have laws that denote specific notice requirements and timeframes for anyone who wishes to sue a governmental agency or entity. If the plaintiff fails to follow the terms of such a law, he or she will commonly find the lawsuit quickly dismissed by the courts. From an emergency services perspective, negligence is one of the most significant and routine means of legal risk exposure. Those within firefighting and EMS professions are also considered to be just that, professionals, even if they are volunteers. Breaches of a duty owed are determined by whether or not the firefighter or EMS provider complied with the appropriate standard of care. Did the firefighter or EMS provider act as a reasonable and prudent firefighter or EMS provider with the same level of education, training, and experience under the same or similar circumstances? That is the threshold against which he or she will be measured. As always, the application of state laws is very important within the realm of negligence claims, as such lawsuits are almost exclusively filed within the state court system. Along somewhat similar lines, many states provide some level of legal protection against such claims, especially for governmental entities and agents. Beyond the realm of intentional torts and negligence, there are also strict liability torts that relate to the performance of activities that are considered to be abnormally dangerous, such as blasting operations or the keeping of dangerous wild animals. If a person or entity is involved in such an inherently and abnormally dangerous activity and someone is harmed as a result, that person or entity will be held strictly liable for the plaintiff's injuries, even if the person or entity was not acting unreasonably. Another category of civil wrongs, if you will, includes cases related to products liability. While not strictly a part of tort law, given that products liability law can stand on its own, this is as good a place as any to discuss the subject and its relationship to fire departments and EMS agencies. Within this realm are three different types of actions: negligence, breach of warranty, and strict liability and tort. Given that emergency service agencies and their employees are consumers of equipment and products, a cursory understanding of products liability can be helpful. The first theory for recovery against a manufacturer for a product that causes harm to another is negligence. If the commercial defendant was unreasonable in the design or marketing of a product, or it failed to discover an inherent danger within the product, that defendant could be negligent in the design, production, or marketing of the product, giving rise to a products liability lawsuit. Manufacturers of products are also obligated to take steps to notify consumers of a defect that is discovered after a product is released, which explains the need for recall notices when a defect is discovered in a product. Another type of products liability involves an alleged breach of warranty. This claim is derived from contract law and can be based upon either an expressed warranty made by the product's manufacturer or an implied warranty of merchantability that arguably exists for all commercial products. As expressed warranties are used as a marketing tool to convince people to purchase the product, a breach of an express warranty related to the quality of a product can be used as a basis for a product's liability claim under breach of warranty. An implied warranty presumes that the product is fit for its intended use. It is this aspect of products liability law that results in stickers on electric hair dryers telling people not to use them in the shower or bathtub, or warnings on lawn mowers telling people not to run over their feet with the lawnmower. Disclaimers on products provide constructive notice as to what the product is not designed to do, thus ensuring there is no implied warranty with regard to that prohibited or discouraged consumer use of the product. The third method of recovery in a product's liability case is strict liability in tort. If a commercial product harms someone due to a manufacturing or design defect, anyone involved within the stream of commerce for that product can be sued under strict liability in tort. This area also includes defects in warning, which once again relates to an inadequate or missing warning as to how the product is to be or should not be used. In that regard, it is necessary for a product's manufacturer to warn a reasonable person of all significant risks associated with the product. That is why every pharmaceutical commercial on television lists all the potential side effects of taking a medication. Pharmaceutical companies learned years ago that they cannot rely on physicians to ensure patients are fully informed as to the benefits and, more importantly, risks associated with taking a specific medication. It is also why the clerk at your local pharmacy will not let you leave the counter with your prescribed medication until the pharmacist consults with you to ensure you are familiar with the medication. Aside from the fact that fire departments, EMS agencies, and their employees are consumers of various products, the impact of knowing about products' liability lies within something known as spoliation of evidence. If someone is injured by a product and that product is ruined by the government agency to the point where the manufacturer, third-party investigators, scientists, or insurance companies cannot determine the precise cause of the failure, the government may actually have to pay damages to the plaintiff in lieu of an insurance company or the manufacturer of the alleged defective product. This is an issue that tends to arise within the context of fire investigations where the investigator suspects that a particular product or device, such as a toaster, coffee pot, or electrical outlet, is responsible for the fire. If the investigator tries to evaluate or examine this suspect product and winds up damaging the product or destroying the evidence within the product that related to the alleged failure, spoliation has occurred. Nuisance is another interesting civil harm that bears mentioning. If a substantial and unreasonable interference with the right to use and enjoy one's own property occurs given the activities of another, a nuisance, either private or public, may potentially exist. A private nuisance is where a defendant's activities substantially and unreasonably interfere with a single plaintiff's use and enjoyment of his, her, or its land. Examples of such activities may include bright lights, loud noises, or unpleasant odors. To put a nuisance complaint into context, think of any number of comedy movies produced that deal with a poor or hostile relationship between neighbors. One such movie dealt with a young family who had a fraternity move next door, and hilarity obviously ensued. Outside the auspices of a movie, in real life, the actions of the fraternity would surely have constituted a nuisance, as the late noise, music, traffic, and lights did indeed substantially and unreasonably interfere with the young family's use and enjoyment of their house and property. On the other hand, if that fraternity house existed prior to the young family moving in, the fraternity may be able to use the coming to the nuisance doctrine as a defense to the young family's nuisance complaint, given that the defendant was there first, and it would have been reasonable for the family moving next to the fraternity to anticipate the noise and other joys that would come from moving next to a college fraternity house. There is also something called a public nuisance, where the activities of a person, or more likely a business entity, impact an entire community or group of private property owners. If a public nuisance exists, only the government can file the lawsuit against the prospective defendant. Private parties cannot sustain a public nuisance lawsuit unless the private party can show that it is suffering an injury that is unique and different from the injury suffered by the community as a whole. As far as any public nuisance lawsuit is concerned, the government must show that the defendant's activities are responsible for an unreasonable interference with the health, safety, and/or morality of the community impacted. The impact of nuisance claims to emergency services typically entails the locations of fire and EMS stations within a community, given the noise generated by such a station. Such noise would probably be considered a public nuisance, and because only the government can file a public nuisance lawsuit, it is highly unlikely that the government will sue itself, or even a private agency, given the activities associated with that very important and necessary occupancy. If a neighboring property owner could show a substantial and unreasonable interference with the use and enjoyment of his or her property that is unique from the others in the area as a result of the fire or EMS station's activities, however, a private nuisance claim may not be outside the realm of possibility. Maybe the fire or EMS station is old and it has a fuel oil system that leaks onto a neighboring property. As such a harm is suffered by one plaintiff only and not the entire community, something like that could possibly constitute a private nuisance. Defamation is another type of civil wrong whereby one person, through a form of communication, verbal or written, harms the reputation of another. For a statement to be defamatory, the defendant must have made the communication as though it was factual. Expressing opinions is different than holding that opinion out as a proven fact. That is why negative online reviews are not necessarily defamatory, because those posting the reviews are predominantly sharing their opinions. Assuming a defendant made a defamatory communication alleged to be fact and not opinion, however, the key to being successful in pursuing a defamation claim is demonstrating reputational harm. There are essentially two types of defamation. The first is libel, which is based upon a written communication. As written communications are more permanent than verbal communications, libel is considered to be more damaging than slander, which is the second type of defamation based upon oral statements. To be defamatory, the communication must convey scorn, ridicule, or contempt, or otherwise lower the plaintiff's reputation in the eyes of a respectable minority in the community. Defamation can occur either intentionally or negligently. For a defamation lawsuit to succeed, the plaintiff must commonly show that he or she suffered specific pecuniary losses, special damages, as a result of the defamatory comments. Such special damages are not required, however, in cases of slander per se, where the defendant's defamatory statements accuse the plaintiff of being unfit to perform in a profession or trade, having committed a crime of moral turpitude, a felony or a bad misdemeanor, having a loathsome disease, or having participated in deviant sexual conduct. Again, in such cases, these types of statements are considered to be so offensive or stigmatizing that no specific economic damages need to be proven. There is also a different threshold for proving defamation in the case of a plaintiff who is considered to be a public figure. Public figures make their living in the public eye and, as a result, must be able to tolerate more scrutiny by members of the public than a typical private party. Such public figures would include politicians, celebrities, professional athletes, news anchors, and even public employees who are involved in matters of public concern, especially higher administrators such as a fire chief or EMS manager. In the case of a public figure, there cannot be a successful defamation claim unless the public figure can show the person making the defamatory statement acted with actual malice, which means the communication was made with knowledge that the information was false, or that the defendant made the communication with a reckless disregard as to whether the statement was true or false. As mentioned previously, defamatory statements are those made with veracity as to their authenticity. The person making the statement holds it out as fact. Therefore, the best defense to a defamation claim is that the statements were actually true. Stated another way, truth is an absolute defense to a claim of defamation. So how does defamation impact fire and EMS services? The first scenario would be where a member of the public criticizes an agency's leadership. In such a case, that leadership, commonly the chief and officers of the agency, are considered to be public figures. Therefore, actual malice must be shown. Another scenario that can arise within the defamation arena is where an emergency services worker reports someone of a suspected crime, typically under a mandatory reporting law. If that is the case, the worker is probably justified and privileged to make such a report under the law. Many such laws provide immunity from civil and criminal proceedings if such reports are made in good faith, and such good faith reporting is usually presumed by the law. That does not necessarily stop the alleged perpetrator of the crime from claiming the emergency worker defamed him or her, however. Lastly, given the explosion of social networking along with online communication and publication methods such as wikis and blogs, firefighters and EMS providers must be just as cautious as to what they post in such forums as anyone else. Additionally, while not necessarily defamation, releasing protected health information about a patient through such mechanisms can also lead to significant liability under HIPAA and state patient confidentiality laws, which will be discussed in greater depth in a later chapter. There are numerous laws that also recognize what are known as invasion of privacy torts. These torts are based upon the premise that Americans have a right to a certain amount of privacy, and when that right is breached, depending on the nature of that breach, a lawsuit may be prudent. While invasion of privacy torts can vary between jurisdictions, the most common include commercial misappropriation, intrusion into seclusion, public disclosure of private true facts, and false light. A commercial misappropriation occurs when a defendant tries to use the likeness of another for commercial gain. One of the best examples would be in the area of professional sports. Professional athletes have a right to market their brand, whether that includes their faces, reputations, or other distinctive features. If a third party attempts to use that likeness without permission, a commercial misappropriation may have occurred. Reporting newsworthy events is still considered to be acceptable, however, and does not qualify as commercial misappropriation. Intrusion into seclusion occurs when the defendant's intentional conduct interferes with the plaintiff's sphere of privacy. Intruding into someone else's private space through electronic or other means, such as hidden cameras, eavesdropping, or drones with cameras, would typically give rise to this invasion of privacy tort. We discussed defamation and stated that truth was an absolute defense to defamation. Just because someone is reporting or sharing true facts does not necessarily mean that person is right to do so, however. If a person disclosed private facts about another that are highly offensive to a reasonable person, public disclosure of private true facts probably occurred. As with commercial misappropriation, newsworthy events and facts are permitted to be shared with the public and cannot be the basis for a public disclosure of private true facts lawsuit. Also, if the plaintiff him or herself shared the information with someone else, he or she cannot recover against that person if the information is subsequently shared. If you have a deep, dark, dirty secret, sharing that secret with someone else means it may not be a secret for long, and there may be nothing you can do about it. False light is an invasion of privacy tort that is somewhat similar to defamation, but with a lower threshold, if you will. Portraying someone in a false light could include comments that are harmful to the plaintiff, even if they are not considered to be defamatory. While there are some defamation cases, such as slander per se, where the plaintiff does not have to show damages to be successful in the lawsuit, all false light lawsuits require damages to be proven by the plaintiff to be successful. As far as fire and EMS is concerned, we know that firefighters and EMS providers are often privy to very private information. Whether that be medical information for a patient or something a firefighter saw in a private residence while investigating a smoke alarm, the public places a tremendous amount of trust in emergency workers and should rightfully be able to assume private facts and circumstances remain just that, private. A breach in that trust can not only undermine the public's faith in emergency workers, but it can also give rise to personal civil liability for an invasion of privacy lawsuit. Keep in mind as well that EMS providers are also governed by patient privacy laws such as HIPAA and other state laws. These laws will be discussed in greater depth in a later chapter. Occasionally, a person or entity may suffer economic damages at the hands of another. Generally speaking, there is no duty to avoid the negligent infliction of pure economic loss unless there is some type of special fiduciary or financial relationship between the parties, such as that which exists between an accountant and his or her client. Economic losses that occur contemporaneous with a physical harm are simply added into the calculation of damages. Pure economic losses without any type of physical harm, however, are commonly not recoverable under negligence. With that being said, there are indeed some torts that address financial damages suffered without any associated physical harm. The first such tort is deceit or misrepresentation. This economic tort occurs when one person makes a misrepresentation to another, the other person relies upon that false information, and economic damages result. For deceit to occur, the misrepresentation must have been made by the defendant with knowledge as to the falsity of the information or with a reckless disregard of the truth. Given this mental state, negligently providing incorrect information does not qualify as deceit. Defamation as applied to the business world constitutes the tort of injurious falsehood, which is also referred to as trade disparagement, trade libel, or business defamation, depending on the jurisdiction. In this tort, a defendant knowingly makes a false statement to another, resulting in a specific economic loss. If the statements were made with malice, the plaintiff may even be able to recover punitive damages against the defendant. Two additional economic torts include interference with contract and interference with prospective economic advantage. The prior, interference with contract, occurs when a defendant deliberately interferes with a contract between the plaintiff and a third party. The latter, interference with prospective economic advantage, is where a defendant acts intentionally to disrupt an economic relationship between the plaintiff and some third party that holds the probability of a future economic benefit to the plaintiff. Within the realm of fire and EMS, it is probably unlikely that a fire department or EMS agency will ever have to deal with an economic tort lawsuit. With that being said, fire departments and EMS agencies are involved in the purchasing and procurement process on a regular basis, and governmental agencies in particular may have to consider policies, procedures, or laws related to that process. Backdoor deals and kickback schemes are commonly illegal and could give rise to liability under an economic tort theory of recovery. Vendors can be somewhat unscrupulous when seeking to make a sale, and a fire department or EMS agency could possibly be testifying in a lawsuit between two prospective vendors. Having a cursory knowledge of these economic torts is not a bad idea for any emergency services manager. That brings us to the end of the various civil wrongs to discuss within this chapter. There are obviously a lot of them out there. Before we wrap up, though, there are a couple other subjects that relate to civil law that must be examined. The first is the subject of joint and several liability. There is no law that states a civil lawsuit involves only two parties, and it is not uncommon for a single lawsuit to have multiple plaintiffs or multiple defendants. In cases where there are multiple defendants and the plaintiff wins the case, one may wonder who is left to pay the damages. Which defendant is ultimately responsible to the plaintiff or plaintiffs? While the answer can vary depending on the jurisdiction, the most popular type of defendant liability in civil cases is called joint and several liability. Let's begin by splitting joint and several apart. Under the doctrine of several liability, the plaintiff can sue defendants separate or severed from each other. Joint liability, on the other hand, gives a plaintiff, or a defendant for that matter, the opportunity to join or pull multiple defendants into the lawsuit. In jurisdictions that recognize joint and several liability, the plaintiff can sue one or multiple parties and can recover full damages from multiple defendants or from a single party. To elaborate, consider this example. The plaintiff wins a lawsuit against two defendants. The damages were $100,000, and defendant A was 25% responsible, and defendant B was 75% responsible. While you would think the plaintiff should recover $25,000 from defendant A and $75,000 from defendant B, the plaintiff really does not care who pays what, so long as he or she is made whole, the full $100,000 in damages. Under joint and several liability, the plaintiff may recover the full $100,000 from defendant A, who is then left to try and recover the other $75,000 from defendant B through the process of subrogation. Maybe defendant A has better insurance than defendant B, or defendant A is a large company with deep pockets and defendant B is a private party with little to no financial resources. Regardless, the plaintiff is entitled to his or her damages, and the defendants are then left to figure it out, so to speak. As an employer, it is also important to understand the doctrine of respondent superior. This doctrine will be discussed in greater length in a later chapter as it relates directly to the employer-employee relationship. For the time being, however, just know that the employer is typically held responsible for the acts of its employees while functioning within the scope of their employment. Thus, if an employee is responsible for a negligent act that causes damages to another, the employer will be responsible for those damages given a resulting lawsuit. With that, we are at the end of the chapter. While I apologize for the length of the presentation, there was obviously a lot of information within the chapter as our laws recognize many civil wrongs, and negligence in particular is a very important topic for emergency services personnel to understand. To summarize the chapter, a tort is a civil wrong that occurs when a person, entity, or group harms another person, entity, or group. An intentional tort occurs when the tortfeasor, the person who did the bad act, commits an intentional, volitional act that causes harm to the victim. If the tort involves bodily injury, the plaintiff can seek recovery for damages. As a defense to an intentional tort, it can occasionally be possible for a person to consent to torturous conduct, either expressly or implied through his or her actions, depending on the circumstances, thus eliminating the risk of liability for the potential tortfeasor. Nuisance is the hindrance of the right to use and enjoy one's land given the actions of another. Such claims can be either public or private in nature depending on the circumstances. Negligence occurs when 4 elements are met. Someone owes a duty to another, and there is a breach in that duty, typically given a failure to act reasonably, that causes damages to that other person. Causation in negligence includes both actual cause and proximate cause. Some laws provide immunity to certain people or entities for specific acts or activities, which alleviates legal liability for any damages that may result from those actions or activities. Such immunity is recognized as either sovereign, which applies to governmental actors, and statutory immunity, which may apply to both government as well as private parties. As far as government immunity is concerned, discretionary acts are commonly afforded immunity from tort claims litigation. Regardless of whether the immune party is governmental or private, immunity protection typically does not extend to acts of gross, willful, or wanton negligence. Defamation is another tort that was discussed within the chapter. If one person, through either a written or oral communication, harms the reputation of another, defamation may have occurred. If the person impacted by defamation is a public figure, however, the threshold for establishing defamation is elevated to requiring the plaintiff to show actual malice on the part of the individual defendant who made the alleged defamatory statements. Besides physical injury, there are some torts that address financial harm that occurs without any associated physical harm. As far as civil cases and procedures are concerned, there is no limitation as to the number of parties that can sue or be sued, which means some lawsuits may have multiple plaintiffs and/or defendants. Looking ahead, the next chapter in this series covers contracts and the legalities involved with the formation, maintenance, and dissolution of binding agreements between parties. It is definitely an important topic for any fire department or EMS agency manager.